Hello, everyone. Welcome to today's webinar. We're going to be getting started in just a moment. Thank you all so much for being here. On behalf of the California Labor Lab, a NIOSH Center of Excellence for Total Worker Health, we're pleased to welcome you to today's webinar. We have a few housekeeping items before we get started. You'll be muted during this presentation. If you'd like to ask a question, please enter it into the online Q&A. Questions entered via the Q&A feature will take priority of those entered in the chat, and will save time at the end of the presentation to address as many questions as possible. This presentation is being recorded and will be made available on the California Labor Lab and Center for Occupational and Environmental Health YouTube page. Presentation slides will also be made available. Please email coehce@berkeley.edu for a copy of the slides, and I'll put that in the chat as well. All participants who logged in today with their registration email for the full live presentation will receive an email with a link to the evaluation form that will qualify you for a certificate of completion worth 1 continuing education contact hour. Once the evaluation is completed, you'll be able to access and print your certificate. Without further ado, I'm going to hand it over to my colleague, Dr. Christina Banks.
Hello, everyone, and thank you, Michelle. I am very pleased to be able to moderate this webinar today entitled Supporting Healthy Work, Law and Regulation. My colleague and friend, Mr. Walter Stella, will be presenting today. Before he begins, I'd like to tell you a little bit about him. Mr. Stella is a senior employment law attorney with more than 30 years of experience advising employers on challenging workplace issues and providing practical solutions that minimize legal exposure in a heavily regulated business environment. He frequently serves as outside general counsel on employment law for clients, as he typically is their first point of contact when employment issues arise. Mr. Stella is widely respected for his ability to assess problems, design smart legal strategies, and oversee cost-effective resolutions. In his day-to-day practice, Mr. Stella handles employment law litigation, settlement negotiations and arbitrations, negotiates executive contracts, and provides proactive state and federal regulatory counseling. He has assumed leadership roles throughout his career with prestigious firms, including Miller Law Group, and more recently, Cozen O'Connor. Outside of his practice, Mr. Stella is deeply involved in the Bay Area legal community and pro bono service. He routinely advises the Equal Justice Society and National Center for Youth Law on employment law issues, and he serves as a lead organizer of the biannual one-day pro bono employment law clinic run through a partnership between the San Francisco Bar Association's Justice Diversity Center and the Association of Corporate Counsel's Bay Area chapter. Mr. Stella earned his bachelor's degree from Marquette University and his law degree from Cornell Law School. Let me now turn to our speaker today, Mr. Walter Stella.
Chris, thank you so much, and good afternoon to everybody. Thank you for joining. So, when we think about the employment relationship from a legal perspective, think of it as a fundamentally contractual relationship. This contractual relationship, which is really the fundamental building block, if you will, of our economic system, is one of the most heavily regulated contractual relationships that exist. And what I'm going to be talking to you about mostly today is that regulation. And if you can think of, we're on Zoom here, you can think of the Zoom window that we have, that contractual relationship, so long as it exists within this Zoom box, the regulatory box, we can control as parties what we agree to and what we don't agree to with respect to our fundamental contractual relationship. But it's that regulatory box that sets in motion and is supported primarily by public policy and supports the concept of a healthy workplace. The concept of a healthy workplace, I am interpreting it very broadly, and you'll see that I'm going to cover several areas of the law that I think do impact the healthiness of a work environment. One is the physical workplace and the attempts that we have to control or limit primarily physical related issues. And that's through OSHA and Cal-OSHA, and I'll talk about that a little bit. But then also to have a healthy workplace, we refer to unfair employment practices, which deal with unlawful behavior that may occur in the workplace. The most common of those are known as discrimination, harassment, retaliation, but wrongful conduct occurring in the workplace that in litigation, which is something that I do, you see oftentimes the harm or the damage being more emotional distress, it's referred to. Also protections in what we refer to generally as the wage and hour area, which is not just financial protection, but protection from what might be seen as employer abuse in the way employers may otherwise interact with their employees on workplace hours and the way in which folks are asked to work and what they're being paid, frankly. And then, of course, if you do have a disability and what that means and what is triggered, what are the protections? What kinds of obligations do employers have? Again, this is the focus of laws and regulation, not necessarily the right thing to do, but what are the must things that should be done? And then finally, I think any discussion about a healthy workplace also has to include a discussion about what protections individuals have when they're away from work, whether they can take time off from work and still have their job be protected. So I'm going to talk about all of those things. I'm going to say in advance, I'm going to touch on, there's a lot of material. I do want to leave time for questions, and I invite questions. With that said, because of just the amount of regulation that we have, I'm not going to be able to go into great detail into any of this, but really touch on the beachfront, and hopefully that will invite some questions that you may have. So let me start out with OSHA and California OSHA and the interplay here. And this is a good place to talk about when we talk about laws and regulations, where are they coming from? And what I mean by that, we have a federal system. So we have federal laws, we have state laws, we even have local regulation in certain cities. I'm in Northern California, Berkeley, Oakland, the city of San Francisco, where I am currently, where my office is, all have employment-related requirements. Some cities, like San Francisco, even have agencies that focus on the enforcement and interpretation of those rules. We do have those kinds of agencies at the state level. We have them at the federal level. And of course, we have a court system, both at the federal and state level. All of those forums bring in the laws and regulation that are developed in advancing a healthy workplace. All of those. And oftentimes they can be contradictory, they can be unclear. And that is where there's sometimes a bit of confusion. Now, in the Cal-OSHA and OSHA realm, OSHA is federal, the Occupational Safety and Health Administration. A few states, like California, were able to provide a program to OSHA that OSHA agrees with and approved, which means that California OSHA is what employers primarily, not exclusively, but primarily follow in California. They align very, very well. California has stricter rules that employers would need to comply with. But I'm going to refer to both OSHA and Cal-OSHA. The real focus of OSHA and Cal-OSHA is to provide a workplace primarily focused on eliminating physical risk to individuals that are at the workplace. It starts legally with the concept of a general duties clause, which is the general duty that every employer may have toward their employees in providing a safe work environment. But then there is more focus at times when, depending upon the type of work, if for example, employees are being exposed to certain dangerous chemicals, there are going to be certain standards There's a requirement that you provide notification to employees. There's a set of requirements with respect to preventative measures that employers would have to employ, and then maintaining records so that in the event of some kind of hazard, some kind of mishap that occurs at the workplace, that there would be identifiable evidence as to what the problem is or was and what needs to be done to correct it. So that in general terms is what we have as far as occupational safety, as far as laws and regulations. Slightly different in the approach on the federal side versus the state side. Section 5A1 of the federal law is for an employer to know what recognized hazards exist and eliminate them or limit those hazards in order to protect employees. California's version of this general duty is to impose upon an employer a much broader obligation, one that requires that an employer provide an employment workplace that is both safe and healthful for the employees. Broader, it's been interpreted to be a broader concept in California than what we have under the federal OSHA rule. So this general duties clause comes into play as a general matter, even when you don't have specific regulations that Cal OSHA or OSHA has provided to an employer because of the industry they're in, or chemicals or whatever it might be that has called into play these regulations, these specifics that an employer is required to follow. You do have this umbrella obligation that even if we as OSHA, Cal OSHA haven't figured out that there is a known hazard or there may be some detriment that if we don't fix, maybe a problem, we haven't identified it for you, we haven't set the specific regulations, you as an employer have this obligation to provide that kind of protection. So that's the general duties clause. There's also an obligation to affirmatively report in limited circumstances. What are the limited circumstances? One is if there's a fatality. If there's a fatality, you must report it to Cal OSHA, and almost inevitably that will require Cal OSHA to come out and do an inspection and determine whether there have been any specific violations. The other is whether there's serious injury or illness that occurs. And that's defined in the law. It's hospitalization, it's amputation, it's loss of an eye, or some kind of permanent disfigurement, a serious permanent disfigurement. There are record-keeping requirements that in the event it's not a serious injury or illness that employers are obligated to maintain. And that's in the event of an inspection. And Cal OSHA they have the right to have an inspection conducted at their will. That's the law. So every employer is subjected to a potential inspection, with or without there being an injury at the workplace. So general duties clause, specific regulations to follow in certain industries with respect to certain types of machinery, et cetera, and then an affirmative obligation to report things in the event that there's a fatality or a serious illness or injury. For California, unique to California, all employers are also required to have an injury and illness prevention program. What is that all about? It requires an employer to have a model program, a model policy, this is supposed to be in writing, that allows the employer to assess and identify what the harmful risks might be in the workplace, take preventative steps that are necessary, including training, notification to employees, et cetera, and then determine potential resolutions in advance. What are you going to do in the event of? And oftentimes that's a two-step process. Think of a fire that's occurring. One is to designate certain individuals. The other is to have an escape route. So have something that would allow individuals to respond to certain types of hazards or issues that come up, and a plan that gets executed in the event that the harm you're trying to avoid actually occurs. That's the IIPP. All employers in California are expected to have that. And the latest Cal OSHA rule is that IIPP is supposed to have a COVID prevention component to it. Either that is set apart but oftentimes it's included within the IIPP program so that it's included as part of a known hazard that an employer would need to deal with. So this is what we think about oftentimes when we think about workplace safety. You're thinking about the physical issues that might arise. CalOSHA is not only exclusively set on that, but that's where the primary focus is. So what about mental harms that could occur in the workplace? And I'm generally referring to this as unfair employment practices. Oftentimes when we have discrimination, harassment, retaliation claims, the primary harm that's at issue, in addition to potential wage loss when you're talking about a wrongful termination case, is that we're talking about emotional harm that may have occurred to the individual at the workplace. So what do we do in our system to try to prevent that and to try to assist or require employers to do the right thing? There are two very, very broad concepts. One is the notion of protected classes. The other is the notion of protected activity. Both of those define, if you will, when we talk about the areas of discrimination, harassment, and retaliation, the type of protections or at least the approach that we take in our federalist system. We have both federal law, state law, and again, sometimes local laws that address this. Protected classes, it's just exactly that. It's probably what we're all very, very familiar with. The notion that someone should not be discriminated against because of race, because of gender, because of age, for example. Those are our protected classes. Those protected classes cannot be the reason that an employer takes action. You can do it because of poor performance. You could do it for other legitimate, lawful reasons, but not because of those protected classes. Protected activity is a little distinct. That is, what if someone engages in conduct that's legally protected, but then is retaliated against? What happens then? Is that protected? And the short answer is yes. So protected activity is my complaining about the possibility that I might be discriminated against. It's my taking advantage of a lawful benefit that I'm entitled to. I'm going to talk about these a little bit later in the program. Anything that is legally protected activity is considered protected activity if that triggers an adverse action on the part of the employer to demote, to penalize, to terminate. That is considered retaliation. It's a cause and effect. I do something that's legally protected, and that caused the negative action that was taken by the employer. That, in a nutshell, is what we talk about when we talk about discrimination, retaliation. I'll talk about harassment in just a second. One of the things that I'd like to talk about when I talk about this area is where is the direction? Where are we headed? What we've seen is a number of expanded protections over the years, particularly at the state level. The state is much more protective than at the federal level with respect to protected classes and ultimately protected activity. Prohibition on discrimination due to breastfeeding and related medical conditions. Gender identity and gender expression. Gender expression is a very, very unique concept to California. Gender identity, probably all familiar with, is how you identify or you choose not to identify. It's seen as a spectrum, and it's protected all throughout that spectrum, if you will. There isn't a specific gender identification that is protected. It's anything and everything and nothing at all with respect to your gender identity. Gender expression is how you dress, how you comport yourself, how you may be in contradiction to the stereotype of what your gender identification or your assigned gender may be at birth. So if I want to wear scarves that may traditionally have been viewed as women's scarves, regardless of how I gender identify in California, that's protected. In the United States federal system, it wasn't until 2020 that the US Supreme Court finally came out and said that under our federal law, that both sexual orientation and gender identity are protected under the term of sex, which is what's used in gender under our federal law. In California, what we've seen are other expansions like national origin. The concept of national origin is a much broader concept than simply what your national origin may be genetically. It goes farther. It goes to who we associate with and the churches that we attend, the schools we belong to or send our kids to the extent that any and all of those aspects might in some way be associated with or connected to someone's national origin. Any and all of those things, that activity is all protected. The Crown Act was something that was passed in 2019, and it expands the concept of race. Again, not just the actual genetic race that you may belong to or that you don't belong to, but also hairstyles, hair texture, these historical traits or traditional stereotypical traits that may be associated with race. So what we're seeing is an expansion of the types of protections that we have with respect to unfair employment practices, and then protections that may have been quote unquote on the books for quite some time, that the concepts of race, of national origin, of gender being expanded to give greater protection within the workplace. Harassment is oftentimes what I claim to be a two-person issue. What do I mean by that? One is you have to have a victim of harassment. That means that if I'm the victim, I have to actually be offended by the conduct. I have to be impacted by the conduct. Could be that everyone that's on this webinar could be looking at a particular type of conduct and say, well, that's really offensive. If I'm not offended by it, I'm not a victim of harassment. The other person is an imaginary person. It's that reasonable person in my shoes. What does that, as a practical matter, end up being? It's a normative standard in our society. It means that if I am in front of a jury, it's going to be 12 of my peers that will determine whether a reasonable Walter would have been offended by that conduct, regardless of whether I am or I'm not. If I'm bringing a claim, and presumably I am, would a reasonable person be offended by that conduct? And it attempts to create a normative standard so that there's some objectivity involved, arguably. And that's the way we look at harassment. In California, we have requirements around training as to what that harassment is. It used to be at 50, it's now at 5. So again, a trend within the law as far as the size of the employer. So not only are we seeing expanded coverage with respect to what are the protected classes and or the protected activity, but an expansion as to who are the employers that must abide by those protections. The harassment training, if you're an employer that have 5 or more employees, you have to provide this training. For supervisors, it has to be a 2-hour training. For non-supervisors, it's a 1-hour training, and it has to happen every 2 years. It also has to happen within 6 months of someone's hire. So it's this constant evolution and requirement. Not all states have that requirement. It's not a federal requirement, but it is a requirement that we have in the law. So it requires employers to have not only the training, but also the policies behind it. It's one of the few areas where policies are actually mandated legally that you have that, and that you have a course of action in which persons who think that they may have been exposed to harassment or may be subjected to harassment can complain internally about it, so that there is a obligation on the part of employers to respond and to remediate the issue. All of those are actual obligations. Trends in the law. What are the new areas? What are the areas that we're seeing when we're talking about a healthy workplace and talking about unfair employment practices? One of the areas, lactation accommodation. This is an obligation now that employers have, where they have to allow for a reasonable amount of time and a location within the workplace to allow for lactation. There is a potential defense if you're a smaller employer, you have less than 50 employees, to say it's an undue hardship. It's a high standard, a very, very high standard. Again, public policy coming in to imbue protections to what is otherwise considered a contractual obligation. One way to think about it is that there is market failure, that the market is not providing this kind of protection on its own. And the legislature, courts, in this case, it's the state legislature, Congress are enacting laws that fill that gap that otherwise would be a gap where there wouldn't be this kind of protection. The Contraceptive Equity Act of 2022, this, of course, is something that ever since, as many of you know, the Roe v. Wade decision was overturned, is something that has played out in various states throughout the US on kind of both sides of the fence here. In California, beginning this year, we have a new protection, a new protected class, as well as protected activity, that anyone who engages in reproductive health decision-making can't be retaliated against because of it, whatever that may be, again. So it is a protection that California, due to its view of public policy, has instituted. And obviously we can see that, there's this debate, red states, blue states, and in which direction folks are going. In California, we now have that as a protection. So employees are protected in the type of reproductive health decisions that they make. An outflow of the #MeToo movement is protection and a really strong effort to try to close the pay disparity gap. Historically, there's been a pay disparity gap. The focus has been among genders, male versus female, but also race and national origin has come into play. So what we've seen recently is a effort on the part of the legislature to fill in where it can, to approach things in a way to try to close that gap. One is to force employers or preclude employers not to rely on salary history. Why? Because that would only, to the extent that you have certain members of our society underpaid to begin with, if you were to rely on salary history, that would only perpetuate the problem. At least that's the public policy behind it. By precluding, by limiting, by making it unlawful for employers to now continue to rely on salary history, the thought is that that would begin to break down or disintegrate that existing disparity. So employers can no longer, in California, can no longer rely on, ask about someone's prior salary. A couple of exceptions. An employee can make it known, can volunteer, an applicant, I should say, can volunteer that information, perhaps as part of his or her or their negotiation over a salary. So they can volunteer that information, but an employer cannot ask that information, nor can it rely on that information unless, again, it's being volunteered as part of the negotiation on the part of the applicant. The other is that an employer can ask for salary expectation. An employer can ask for salary expectation. Challenge there sometimes, at least the argument has been, is that, well, what is, if somebody, if somebody's already underpaid and you ask them what their, pay expectations are, isn't it going to, in some ways or another, be connected to the type, to how much money they're making, because that's all they know. And hence, pay transparency is another area of the law that we're seeing developments. What is pay transparency? It's basically requiring employers to make known what the pay scale would be for a particular job. If you're 15 employees or larger, you now have an obligation in California to disclose the pay scale when you advertise for the job. So you have to just put it out there. If you're an employee or an applicant, you can ask, regardless of size. You could be an employer of 1 or 2 or whatever size. If an employee requests knowing what the pay scale is for the job that employee has, or an applicant for the job that applicant is applying for, they are entitled to know what the pay scale is. Lots of questions around what do we mean by pay scale. The statutory definition is that the pay scale is what an employer reasonably expects to pay for that job. It's still, that helps, it doesn't answer the question. In other words, is it simply looking at individuals who already have that job and look at that pay range and disclose that pay range? That may be the answer. In some instances, it would be something different, what an employer may reasonably expect to pay. Seniority may have a factor. So someone who's been working at a company for 10 years may be paid at one level, and someone who's about to start that job may not be paid at that level. That's not reasonable. And this is all being litigated in the courts, but the effort, the policy behind it is to force employers, preclude them from not relying on prior salary history, because that is only going to perpetuate the disparity, and then make that information available to applicants, to employees, so that they know what could be potentially the salary, so that if they're being asked what their salary expectation is, and they're negotiating, they know what the range is. They're not relying on what might otherwise be disparate pay in negotiating their pay as they move from one job to the next. Arbitration is something that's been mentioned a lot. California, in its effort, both at the legislative and at the court level, has attempted to bar mandatory arbitration. So mandatory arbitration arrangements basically is an employer requiring, as a condition of employment, that you agree to go to arbitration and avoid the court system. The general concept is that arbitration, although expensive for employers, is a more favored forum. You're pulling the decision-making away from a jury. You're putting it into the hands of arbitrators, are primarily retired judges and justices. So someone who's seasoned in the law, who may not be necessarily moved by the equities of a case, but be much more focused on what the law is and isn't as far as the application of that law, generally considered a much more favorable forum for employers. Not always true, but that is the thinking behind it. So can employers require that? One way in which California has attempted to attack it is to say that the effort on the part of the employer to mandate that is an unfair employment practice. So it's just like discrimination, harassment, or retaliation. It's the effort at requiring it, that act, is an unfair employment practice. This has been going through the courts since 2020. The act came into, it was enacted, was implemented in 2020. It wasn't in effect for, I'm going to say a minute, it was about a month, when a federal district court in Sacramento issued a restraining order. It has been playing out in the appellate courts. As it currently stands, that restraining order is still in play. The law is still on the books, but it's not in effect. It's not being allowed to be in effect, essentially because of the federal law that preempts the state law. It's the Federal Arbitration Act. So Congress has indicated a strong intent to support arbitration. There's some exceptions to that, but because of the Federal Arbitration Act, California's efforts to limit employers to have the ability to on the enforcement side, to force employees into arbitration currently still stands, still being litigated, but the likelihood that that law will be enacted in full is I would say low, and if I were to predict, very low. We hear a lot about gig workers. We hear a lot about independent contractors. Why is that relevant to what I'm talking about today? That's because if you have a true independent contractor, that person is not being protected by all the laws I've just talked about. So I talked about the employment relationship. I'm talking about the regulatory box that tries to support the healthy workplace. Those regulations don't apply to an independent contractor. So if you truly are an independent contractor, you're outside almost all of the laws that I've talked about. So then the question becomes, who is an independent contractor? You can have an independent contractor relationship, and that really is fundamentally contractual. But whether you really are an independent contractor is not determined by the party's contract. It's determined by these legal tests. It's legal tests that determine whether you're even allowed to be an independent contractor. Three major buckets when we talk about independent contractor. We talk about a variety of these legal tests. We have legal tests in the federal arena, in state arena, depending on the statute, the test will vary. It gets to be a very complicated area of the law. California has adopted something known as the ABC test, and it really brings these three major buckets of factors that really belong in all of the tests that are out there, federal, various states, et cetera. But it's the notion of control, who controls how the work is being done, or if you have the authority to do so, even if you don't exercise that authority. How integral is the work that you're doing? Is it in the ordinary course of business? Is it integral to the person to whom you're providing services? And then C is independence. Are you truly an independent actor, an independent economic actor? Do you have a business? Are you searching for customers? Do you have the ability to make money, lose money? Those are the factors that we're looking at. And in California, those three big buckets of factors, the A, the B, the C, has an and in between them. You got to have all three before you can be an independent contractor. I'll give an example, a plumber. I have a leak in my kitchen and I need it fixed. I call a plumber to come fix it. She has the know-how, she has the tools. All I'm asking for is the end product, fix the leak. I'm not going to tell her what to do because I'm not a plumber. I don't know. Is it in the ordinary course of my being a homeowner? Absolutely not. It's not what I do. I'm just asking for, and even let's say you have a kitchen in an office building, you're not in the plumbing business. So it's not in the ordinary course of the person who's receiving the services. And does that person have an independent business? Yes, she's working for me now, but she'll have other customers. She may set the price at $1,000, believing it'll take 5 hours of her work. It could take 1 hour and she makes more money. It could take her 10 hours and she could lose money or make less money. And that is a true independent contractor. And there's a spectrum there. And the reason for the strictness in the rules is that independent contractors don't get all the protections. If someone is an employee, then they get all of these protections. And that's one of the strong public policies behind why independent contractors, why it's so difficult to be an independent contractor. And this plays into, if you are an employee, what does that mean as far as protections? We have California minimum state law, minimum wage law. We have local laws that may be even higher. The minimum wage law essentially said, contractually, you can agree to come work for me for less, but as a matter of law, I can't pay you less. I have to make sure that I pay you at least a minimum of minimum wage. There's a concept of exempt and non-exempt here, and that is that the individuals who are not exempt, and this means they're not exempt from overtime laws, from minimum wage laws, from all of these protections, they will have more legal protections than exempt individuals. Exempt individuals, and the concept of being exempt is very, very narrow. At a minimum, you have to meet what we refer to as a salary basis test, meaning you have to be paid a certain minimum amount in a certain way, which is a salary, so that, if you work more, you work less, the salary doesn't fluctuate. Salary basis, and then duties. You have to fit within certain silos. You either have to be a manager or executive, a professional, certain standards there, or an administrative, so that you're high functioning, you're relatively highly paid, and because of a number of other factors, you're considered exempt from a lot of the legal protections that otherwise would apply for non-exempt. Again, the marketplace with respect to independent contractors, exempt, non-exempt, operates differently than what the law envisions, and that's why we have so much litigation over that. So if you're a non-exempt employee, this is where the law provides the most protection when it comes to wages, hours, benefits at the workplace. At a minimum, you get required meal periods that are unpaid. You get paid rest breaks. A typical 8-hour shift, the concept is that within the first 4 hours, hopefully, preferably in the middle of the shift, you get a 10-minute paid break. Happens in the second half of your shift as well. And a specific requirement that you get an unpaid meal period that lasts at least 30 minutes. It has to be duty free, and it has to have started at least, if not completed, but at least started before the 5th hour of work for someone who's a non-exempt employee. There's a lot of other requirements around it. If an employer fails to do that, anytime you miss one meal period in a day, you get 1 hour of pay. Anytime you miss one rest break in a day, you get another equivalent of 1 hour of pay in a day as a premium for having missed those breaks. So financial incentives in order for an employer to comply with these specific rules. What about overworking people? It's interesting, the approach that we've taken from a regulatory side is to create financial incentives and disincentives. So can an employee be required to work overtime? The short answer is yes. But what happens? In California, we have daily overtime. Federal law, we have weekly overtime. We have weekly overtime as well in California. But in California, if somebody works 8 hours or more and they're a non-exempt employee, that triggers time and a half. Starts to get expensive very fast. So it makes employers think about whether they want to have someone work overtime or not. And if someone works the overtime, even if the employer hasn't given the specific permission to do so, under California law, under federal law, you have to still pay that person that overtime. One protection that California has is that an employer cannot take an adverse action if an employee refuses to work 7 days in a row. The 7th day is protected. So if an employee wants to take 1 day off in a week, in a full week, subsequent consecutive days, they will be allowed to do so, and there cannot be any retaliation against that individual because of that. So can an employer, as a general matter, require employees to perhaps work more than an employee wants? The short answer is yes, it can. It can even take adverse action if the employee refuses to work those hours. They have to pay for it. There's going to be a premium involved, but an employer can do that. And then what is compensable time? This is an issue that brings up a lot of litigation as well. Certainly for the time that you're actually working, but it's even a broader concept. And in California, it boils down to control. If you're under the control of the employer, oftentimes this comes up, for example, for on-call related issues. If you're told that you need to be, ready to respond within an hour, or, if I pick up the phone and call you, you got to come in, and that restricts your ability to go to Lake Tahoe for the weekend or do whatever it is you might otherwise do on your free time, that may all be compensable time. If on the other hand, what I say is, look, I may call you, I may not call you, do whatever you're going to do this weekend. If I call you and you're available, I'm going to ask you to come in. It's going to be up to you if you have the time. That's not compensable time. I'm not controlling it. You still have the option to do, you have the freedom to do what you might want to do. But if I control you to the point that I limit your ability to do other things, that's compensable time. And that is paid for in California, as well as under federal law, although California is a little bit more strict. The other question that comes up is, well, what about, just a few minutes here and there, going home and checking an email, closing out a store so that you punch out first and then walk to the store and then set the alarm and then make sure the doors are locked, etc. Do you get compensated for all that time? Under federal law, you don't. If it's just a few minutes, it's called the de minimis rule. Under California, you do. We've rejected the de minimis rule. So for non-exempt, and that's where it becomes important. For non-exempt employees, they get compensated at least a minimum wage, overtime if it's overtime, for all minutes that are worked in California. Any time that you are either under the control of the employer or you're actually performing services for the employer, whether it's a minute, you have to be compensated for it under state law. Different under federal law because of the de minimis rule, but it's something that state law we've rejected. So California, as you see, is much stricter. And the same is going to be true for disabilities. There are disability protections. We have the ADA, you're probably familiar with it, Americans with Disabilities Act. That applies to employers with 15 or more employees. Our equivalent statute, the Fair Employment and Housing Act in California, is five. If you're a qualified individual with a disability, there's a legal obligation for the employer to engage in what's called an interactive process to determine whether there's a reasonable accommodation that would allow you to perform the essential functions of the job. There are different standards as to how someone can qualify. It does require either a physical or mental condition or impairment. So that, and oftentimes it's current, right? It's someone saying, look, I have a medical related issue. I need something from the employer in order for me to continue to do my job. And that it has to be, at an initial point, the employer needs to consider it. Whether it becomes reasonable, whether an employer could do it. And then there's also this notion of an undue hardship defense, which is set at a very, very, I'm going to add one more, very high bar for employers to claim undue hardship. Really, oftentimes the analysis is whether what's reasonable, which is kind of related to undue hardship, but then primarily what is and what isn't an essential function, and for how long. There's always a temporal component. So somebody who says, look, I need help for a week or two, that may be seen as very, very reasonable. Whereas somebody who says, look, this has to be changed permanently because I can't otherwise perform the job, or at least these particular job functions, that may not be seen as reasonable. So it's current physical, mental impairment that requires an accommodation. It's past. So just because I had it in the past, I might be retaliated against or discriminated against, and that's a problem. And then also, whether or not I have one, if you regard me as disabled because of the way you're treating me, because of the questions you're asking, because of what you're making me go through, if you just regard me as disabled, all of those are protected under both state and federal law. One of the key distinctions is that it's easier to trigger being a qualified individual with a disability under state law, because there all we need is a physical or mental condition or impairment that limits a life activity. Now, life activity is generally, it's working, but it's also breathing, sleeping, all of the things that we do we human beings do being alive. If there's any interference, even if it's slight under California law, that's enough to trigger. For federal law, it has to be substantially limiting. So it's a higher bar to get there, But employers are required to reasonably accommodate so long as someone can continue to perform the essential functions of the job. And that's the magic test, is what is the essential function of the job? Is it something that's identified in the job description? Short answer, sure, it could be. Is it what they being the employees actually perform? Of course, that's it too. It could be something that is expected even if the person can't necessarily or never did perform that function because of their performance or some other issue. And that the answer there is yes too. So it could be any and all of those things, and it's really fact dependent. But if you are asking for an accommodation, if it means eliminating a non-essential function and is otherwise reasonable and doesn't cause an undue hardship, an employer at a workplace has to provide that to you. And that even goes as far as leaves of absence as well, a short-term leave of absence that allows you to take some time off and be able to come back and perform the essential functions of the job. Whether you need a different reasonable accommodation when you come back is something that an employer has to consider. The law is very clear that it doesn't mandate, there's no black and white rule as to what you have to do, what you don't have to do, what kind of leave is too long, or what's an undue hardship, what costs too much, etc. The law is intended to be fact determined, very specific to the circumstances. And then regarded as is tricky for employers, because by attempting to accommodate individuals, just simply by attempting to accommodate, whether or not someone needs it or not, sometimes an employer oversteps its role as an employer and suggests things to an employee to take leave, to see a therapist, to do this and do that, triggers potentially regarded as, so that if there's adverse action that's later taken, that just simply treating that person, perceiving that person as having a potential disability, whether or not they actually do have a disability. So, treating someone as if they might have a medical condition, et cetera, may be enough to trigger the protections. Final section, and I know I want to leave some time, is what about the time off? What about the time off? many employers are surprised to find out that there is no legal requirement that they provide vacation or paid time off. Lots of legal regulation if you do provide it, but not that you have to provide it. Now, if you do provide it in California, if you have what's called an accrual-based PTO, then there is no use it or lose it. If you accrue it as an employee, you get to keep it. That's different in other states, but in California, there is no use it or lose it. What California employers can do is they can cap it. They can tell an employee that, hey, we're going to give you 2 weeks per year. If you don't use it, it continues to roll over, but we're going to cap you at 3 weeks. You can't cap it at 1 year. You have to give a certain amount of time. We oftentimes think of it in terms of giving 6 months. So like if a year's worth is two weeks, you give 1.5 times the year accrual, you get to 3 weeks. Something like that is enforceable in California. There's also this notion of unlimited or flexible PTO, which is non-accrued. That is also generally considered lawful in California. That's really driven by finances, because in California, accrued PTO is wages, and that has to be paid out upon termination. Flexible or unlimited is not. And I know I'm running out of time. Let me just touch 1 minute really quickly to say other protections, required paid sick leave in California. There's also local requirements there. We may see a law come in next year that would up that. Right now, it's basically 3 days in California that's required. We may see that go up to 7 days. And then a whole amalgam of protections that exist. And we could do 2 or 3 hours or half a day protection on the various leave laws that are there, that are triggered. Again, California being much, much more protective in what employers are covered and what types of triggers trigger these leaves, much, much broader than what we have under federal law. Talked about the expansion. Some of the new leaves that are coming in, we now have a bereavement leave. It's not paid, it's unpaid, but we have that as a requirement to allow that so employers can't retaliate against somebody. Leave for emergency conditions. A lot of folks thought that this was going to be the COVID leave, that if there's like a pandemic, but the law actually makes it clear that it's not about pandemics. What it's about is shooting or earthquakes or something other than a health-related emergency. Some things coming up. Last line, cannabis use. There's going to be there was sort of this ambiguity in the law of medicinal purposes, et cetera. Now, if you're smoking cannabis or using cannabis, I should say, off duty, off site, that and that alone, as long as it doesn't impact your work. If it impacts your work, that's a different story. But that fact and that fact alone, we can't retaliate against, and we may see an increase in the number of paid sick days. I know I've covered a lot, and I know I haven't left a lot of time for questions. I do apologize, but thank you so much for listening. And Chris, let me know if there's questions.
Of course, there are questions, and
Just a few like that.
And they're wonderful ones. And we have about 7 minutes, so that means of the 5 questions that we have, you've got to give short answers.
I'll do my best.
And hopefully that can happen. Okay, so the first question is goes back to very early in your presentation, which is, with the increase in remote and hybrid workforce, what does or where does OSHA requirements enforcement apply to the remote workstation?
That's a really great question. So it does apply. Then the question is, are we talking about remote in the state? If we're talking remote in the state, then yes, those rules technically still all apply. So ergonomic related issues, anything. If you're an employer and you're allowing somebody to work from home, you're still legally obligated to ensure that that person has a safe and healthy work environment. So it still applies. If you're remote outside of California, suddenly it's federal OSHA or that state's rules. So it's all about where you are physically performing the services.
Wonderful. Another related question is, are there types of employment relationships that might be exempt from OSHA requirements? So are there relationships where the responsibility is murkier?
Yeah, well, independent contractor would be would be, I mean, somebody, if you're an employer and you have a physical workplace that independent contractors, the UPS driver, whoever it might be, or vendor that comes and has to service machines or do something like that, you still have some obligations to them because they're there located in your physical workplace. But that's where it gets murky. If it's your employees, if that's the relationship, and that's the fundamental, it's either someone's an employee. If you're a nonprofit, you could have a volunteer. That's the third category, or they're an independent contractor. And if they're an employee, OSHA and the Cal OSHA rules are going to apply. Independent contractors where it starts to get murky, but it depends on what we're talking about. What are they physically on at your location, or are they conducting the services somewhere else?
Okay, so if, for example, if there's an app driver, is that app driver driving their own vehicle covered by OSHA?
Well, the app drivers, this is where there's a lot of fights. If they truly are employees, then yes, they would be cut. The rules that apply in all respects, all the wage and hour rules, all of those things. If they're truly independent contractors, then no, the answer would be no. And that's where the fight, you're hearing about a lot of those legal fights with the app car companies and in this effort to have something in between, the gig worker or something, some protections, but not others, that's being challenged. But yeah, it all comes down to independent contractor, not a lot of protections. Employee, all the same.
There's a theme here, so this is good. Another question, are there legal protections available to people who are discriminated against or mistreated on some basis other than membership in a protected class or engaged in a protected activity? So is it only within those regulatory boxes, or are there other ways to protect them?
It has to be the regulatory boxes. So so I'm this is a ridiculous example, but I'm a Cubs fan. You're a Giants fan. You pick on me because I'm a Cubs fan. I don't have protection. Where I might have protection is, let's say, Cubs fans tend to be 40 and older, and you're not intending to discriminate against me because of my age, but it just so happens that because you're leaning on me because I'm a Cubs fan, that you're impacting a group. We call that disparate impact. That's a more indirect way of protecting. But yeah, great question. If you're not one of the protected classes, or you haven't engaged in a protected activity, again, it morally may not be the right thing to do, but there is no legal protection. There isn't anything that prevents an employer. It's not seen as discrimination or as an unfair employment practice.
Are we seeing some problems with political affiliation these days?
Yeah, well, yeah, we are, and especially, and there are protections there as well. I didn't touch on that, but there are protections, and you see it a lot when you get to election time, because discussions kind of, people are having discussions and are having arguments, and then so much of the political discussion these days, there are racist overtones. That there are discussions like. We've had issues with employee, in the last election, for example, building a wall. Famous, there are folks who, that advocate for that, and then other individuals that say, well, that's offensive to me because because of my national origin, because of my race, because of who I am. That's offensive to me when you talk that way. Not a clear-cut area in the law, but certainly we've begun to see these maybe not clear markers as to what's protected activity and what isn't.
Yep. Okay, another one, the ABC tests you talked about for independent contractors. It seems that the criterion B, the worker performs work outside the usual course of the employer, could unfairly restrict the ability of some businesses to respond to sudden increases in demand for their services. If the contractor, presumably independent contractor they hire, really operates their own independent business and can make their own decisions about how to do the work, it would seem that they are a genuine independent contractor. Is there an idea that such a contractor is very, very likely actually to be under some kind of supervision of the hiring employer, since the employer normally supervises that type of work?
Yeah, I think I understand where you're headed. It's like, look, there are folks out there that may be really truly independent contractors. Plus, as a business, if you're going to impose requirements that's going to make it harder for me to, look, I just need a temporary boost. That's going to make it economically very difficult. There are statutory exceptions. Again, we can spend, an hour or two just on that, where we call it business to business exception, that if you meet certain criteria, you could fall outside of the ABC test. The other thing is that what you do is you fall into the old test, which is called the Borello test, based on a case that we have, California Supreme Court decision. And in the Borello test, when you think of the A, the B, and the C, put an or. This is an oversimplification, admittedly, but put an or in between. So that, yeah, you may lose on B, but you're going to win on C, and you're going to win on A. And that's kind of that balancing that occurs. And the ABC test just tightened it so that you got to have all three. Now there is an escape hatch. There is an escape hatch for what you're describing. You have to meet certain really clear criteria. You meet that, you fall outside ABC, but then you land in Borello, which is going to basically redo the same type of analysis and just balance it all and say, is the balance going to be in favor of employee independent contractor? I will tell you that generally it's still very, very hard to qualify. I mean, the response that you would get from any agency that looks into it is you can still hire the person. You just have to pay the taxes, because that's the other thing I didn't mention. It's about taxes too. Mm-hmm. So they want the legal protections, but they want the taxes. So,
right.
Yeah. Anyway, but yes, there is.
Okay. Can I give you one more? And then unfortunately, we won't have time to ask every question. Can an employer deny your request for sick leave, stating that there are agreed upon deadlines that will be missed?
Not if it's the protected guaranteed sick leave as it currently stands. So that's the 3 days. No denial. If it's been accrued and it's yours to use, an employer can't say no to that.
Great. Okay. Well, we are at 1:00 and we thank you so much for participating today and giving us such an action-packed and thoroughly understandable set of knowledge. And Walter, we are indebted to you. Thank you for taking the time today.
Absolutely happy to do it. Thank you very much, everyone. Have a wonderful rest of your week. And today's Wednesday. Happy hump day to everybody.
Thank you.